Not yet. And the reason we said that is that the Menendez brothers have failed to come clean with the full extent of their criminal conduct, their cover-up, their lies, and their deceit over the past 30 years. As we've explained, the Menendez brothers persist for 30 years, as recently as 2024, in insisting that the reason that they killed their parents, and when I say their parents, I mean their mother and their father, is not because of the sexual abuse. When they testified at trial, they were asked that question specifically. Was sexual abuse the reason that you killed your mother and their father? The answer was no. They said the reason they killed their mother and their father was that they believed on the night of August 20th, 1989, their mother and their father were going to kill them, so they had to kill their mother and their father first. That has always been their defense, the self-defense defense. And we have shown through an extensive analysis of 50,000 pages of trial transcripts over 2 trials, of hundreds of hours of videotape testimony, of a review of prison files, interviews with the Menendez family members that I have personally had, a review of also prior prosecutors and law enforcement, that self-defense defense is a lie. It was a lie back in the 1990s when they presented it at trial and the jury rejected it, and it is a lie today. The Menendez brothers engaged in a deliberate, premeditated killing of their parents based on buying shotguns 2 days before the killings, going ahead and having a pre-planned alibi for the night that they were going to kill their parents, killing their parents in a methodical way to make it look like a mafia hit by shooting their father through the back of his head. Their mother, as she lay bleeding on the ground, reloading a shotgun and shooting her point-blank range through her cheek, shooting the parents afterwards through the kneecaps to make it staged like a mafia hit, and then running out to the police after they called the 911, shouting that someone killed our parents and that the Menendez brothers were going to find that person and torture them. All a lie, as was the self-defense defense. They even added additional lies when Lyle Menendez tried to get one of his girlfriends to say that the girlfriend had been violently raped by the father. A total lie. Lyle Menendez and Eric Menendez got another of Lyle Menendez's girlfriends to say that the mother had tried to poison them. Again, another lie. And the Menendez brothers have never come fully clean with all the lies, cover-up, deceit that they have told for the past 30 years. When and if they do, and they do it sincerely and unequivocally, to the satisfaction not just of the district attorney, but ultimately the court that is going to hear this type of testimony, then the Menendezes will be ready for resentencing. Then the Menendezes will show full rehabilitation. Then the Menendezes will no longer constitute a risk of danger to society. And we started with this analysis that we presented, but most recently the analysis was corroborated by 2 comprehensive risk assessments done by board-certified psychologists for the Board of Parole that was released about a month and a half ago. And what these comprehensive risk assessments essentially said is that the Menendez brothers had been raised in risk level from low to moderate risk of violence should they be released. And what they focused on was not just the rehabilitative efforts, which the psychologists all noted and commended the Menendez brothers for their different and extensive rehabilitative efforts, but what they were concerned about that posed this risk of violence was the deceit that the Menendez brothers had engaged in while the resentencing motion was actually in play since October 2024. Lyle Menendez had engaged in deceit by violating the rules and bringing a cell phone into the prison. Just when you would think you would be on your best behavior, as a court is going to consider your resentencing motion, Lyle Menendez smuggles a cell phone into the facility. And why is that important? Well, a cell phone is not a monitored device by the prison. Every single communication that you have, if you want to speak on a phone or a tablet, there's actually a recording saying it's being monitored by the prison, but not if you bring in a burner cell phone, which is exactly what he did, and he got caught. Same thing with Eric Menendez. Another, in January of 2025, he goes ahead and violates the prison's rules and brings in a cell phone as well. He also admits to engaging in the purchasing of drugs with other inmates, in years before helping inmates engage in tax fraud. Again, what the psychologist looking at this said is that this shows that notwithstanding those rehabilitative efforts, their risk level is no longer low. It is moderate. There's a moderate risk of violence because if the Menendezes are released, they're going to head and not be in a highly structured setting like a prison. And if they can't follow the rules in prison, then the confidence level of these psychologists have dropped on whether or not they will now pose a risk of violence in society. So the court today will now consider evidence. The Menendez Brothers Counsel will most likely present a series of witnesses to try and provide additional evidence to the court. The prosecution has been doing just that, providing the court with as many facts in order for the court to make this final determination on whether or not the Menendezes have been rehabilitated and constitute that risk of danger to society, that if they don't constitute it, they can then have a resentencing, and if they do constitute it, then the resentencing will result in not being effectively resentenced. Because let me leave you with this, what the three options are for the court to do in this case. The court had the obligation, once it made a finding, essentially, that it was going to go forward on its own motion and the people's motion to have the resentencing hearing itself. But that doesn't mean that the court is obligated at the end of it to actually resentence the Menendez brothers. The court is not allowed to increase the sentence for the Menendez brothers, but it is under no obligation to actually change the sentence for the Menendez brothers. So that is one option, that after hearing all the evidence, the court decides not to change the sentence. The second option is that the court does resentence the Menendez brothers to a sentence of life with the possibility of parole. At that point, the Menendez brothers will then go to the parole board. If the parole board were to grant parole, or even if they were to deny parole, it would end up with Governor Newsom, and he makes the final determination, he and he alone, on whether or not the Menendez brothers will ever get out on parole. But there is a third option for the court to engage in today. Because when people talk about the sentence, the Menendez brothers sentence, there's actually two sentences at play. One sentence was the sentence for the killing of Jose Menendez. As a first-degree murder violation with special circumstances, the sentence for the killing of Jose Menendez was life without the possibility of parole. But the second count was dealing with Kitty Menendez, a separate sentence. And that sentence also was life without the possibility of parole for the sentence of Kitty Menendez. So there is a possibility where a court could resentence the Menendez brothers based on the Jose Menendez killing and murder, but choose and then change that sentence from life without the possibility of parole to life with the possibility of parole. But separately, when considering the sentence dealing with Kitty Menendez, for factors that the court can consider unique to the sentence of Kitty Menendez, the court can decide not to change that sentence. So even though there will effectively have been a resentencing for Jose Menendez, there will not be one for Kitty Menendez, and the Menendez sentence overall will be life without the possibility of parole were that circumstance to happen. So again, we're going to have this resentencing hearing over the next several days, 2 days. I don't know if the judge will rule at the very end of it. He can decide to rule on in open court at the end of the hearing. He can decide to take it under submission. He might want to write an opinion about what his thoughts are. He might want to hold another court hearing and announce them from the bench. We don't know one way or the other. That will be up to the court. So that is the overview of what was going to happen today and tomorrow. I'm happy to take any questions.
Mr. Hochman, you sound like you are